Hello, Michigan Realtors, and welcome back to a new installment of the Letter of the Law. Many of you have heard that NAR's proposed settlement agreement requires that a realtor working with a buyer must enter into a written agreement with that buyer prior to showing them a home. Of course, many buyers may be reluctant to commit to an agency relationship this early in the game. As a result, there must be a renewed emphasis on the importance of buyer advocacy and how to communicate the value of buyer brokerage. Yet, even with the most persuasive presentation to a prospective buyer client, listing agents and cooperating agents may find themselves working with unrepresented buyers, if only on a temporary basis until the buyer is willing to sign a buyer agency agreement. For this reason, we think it is a good idea to start thinking about what that may look like. From the seller listing agent's side, the following considerations are important. Showings. Presumably, sellers are not going to want unaccompanied buyers walking through their home. As such, will the seller or the listing agent show the home to the unrepresented buyers? Remember that under license law, an unlicensed administrative assistant or otherwise unlicensed person may not show a home. If the seller or listing agent shows a home, what will happen in the likely event that the unrepresented buyer has questions about the home? In today's world, it is often easy to limit the seller's representations to those contained in the seller's disclosure statement, for the simple reason that listing agents and sellers rarely have any direct contact with the buyers. We don't typically have to worry about alleged oral misrepresentations because there is no opportunity for discussion. Obviously, that will not be the case if the home is shown by either the seller or the listing agent. Remember, while a seller is not liable for innocent misrepresentations made in the seller's disclosure statement, they may be liable for innocent misrepresentations made elsewhere. A seller may also be liable for an innocent misrepresentation made by their listing agent. For these reasons, sellers and listing agents should only answer questions if they are certain of the answer. And to the extent possible, a potential buyer's questions about a home should be addressed in writing. This scenario also highlights the importance of emphasizing to an unrepresented buyer the value of them securing their own advocate during the home buying process. Purchase agreements. It is important to remember that listing agents who draft contracts as a dual agent are acting as a neutral party. While this may not be an easy role, it is certainly easier than drafting an offer for an unrepresented buyer while working for the seller. A listing agent drafting an offer for an unrepresented buyer is not neutral, but in fact has an obligation to act in the seller's best interest. This, of course, does not mean that the listing agent can deceive the unrepresented buyer as to the terms of the contract, but the listing agent cannot offer advice. And the line between explaining something and offering advice can be a very fine line. Listing agents who find themselves drafting an offer for an unrepresented buyer should remember that their role is that of a scrivener, not an advisor. Inspections. We have long advised buyers' agents to give their clients the names of several inspectors to choose from. The concern has always been that if a buyer's agent steers the buyer to a particular inspector, the buyer may hold the buyer's agent responsible if the inspector does a poor job. This is even more significant of a concern if the agent who refers the inspector to the buyer is the listing agent. A buyer who is unhappy with the inspector may believe that the listing agent's close relationship with that inspector made it less likely that the inspector would discover defects in the seller's home. This is unlikely to be true, but it is not difficult to imagine that a buyer could reach this conclusion. For this reason, a listing agent should not recommend an inspector to an unrepresented buyer. Again, the previous examples all highlight the benefit that a buyer receives from their own dedicated advocate, which takes us to the cooperating side. From the cooperating agent's side, showings. Under current Michigan law, although strongly encouraged, a written buyer's agency agreement is not required in order to create an agency relationship. Knowing this, a cooperating agent may choose to work with a buyer who is not yet willing to commit to signing any contract. Now, the terms of the settlement agreement are designed to eliminate this practice. Presumably, the view is that buyers are better protected if the terms of the relationship are spelled out in writing at the very beginning of the relationship. To that end, a buyer brokerage must be prepared and train its agents to have very meaningful conversations with their prospective buyer clients regarding the value of advocacy in the home buying process. Now, this consult should be just as detailed and value-oriented as the consult that a listing agent prepares for a prospective seller. But we must also understand that regardless of how persuasive that buyer brokerage consult might be, there is still a possibility that a buyer wants a cooperating agent to show them a home but is not yet willing to enter into an exclusive agency relationship. Some agents may view showing homes to unrepresented buyers as a business development opportunity. Other agents may simply choose not to work with such buyers. Others may offer buyers an alternative to an exclusive agency relationship. For example, a buyer may be offered a more limited contract, such as an agency relationship that applies only to the particular home or homes that the agent shows to the buyer. Or perhaps a fee-for-services relationship. Michigan Realtors Public Policy Committee is currently studying possible changes to Michigan law that may make it easier to work with these buyers in a more limited capacity. Purging Cause. Now, currently, we have a system in place for determining when a cooperating agent is entitled to be paid. An agent is paid if they are the procuring cause of the transaction as defined in NAR's Code of Ethics and Arbitration Manual. Now, this system covers offers of compensation through the MLS. If MLS offers of compensation are eliminated, procuring cause as we know it will no longer be the standard. Commissions and other payments to a cooperating agent will be purely a matter of contract, whether it be a contract with the listing broker, the seller, or the buyer. If, for example, an agent chooses to show a home to an unrepresented buyer and that buyer chooses to submit an offer on that home through another agent, the first agent will have no claim to a commission as the procuring cause of the sale. As an industry, we will need to develop contracts that clearly spell out how and when a cooperating broker will be paid. In conclusion, if the settlement agreement is approved, there will certainly be significant changes going forward. We are also aware that the Department of Justice, given its recent victory in the Court of Appeals concerning its ability to further investigate NAR rules, will also be monitoring the practices and outcomes that spring forth from this settlement. As an industry, we can and we will adapt. A commitment to education, however, will be essential, as it is likely that there will be many different business models that will emerge. Michigan Realtors is committed to listening to your concerns and assisting in the transition, whether it be through introducing new legislation, developing new forms, or attempting to address your questions the best we can. As always, thank you for tuning in, and we will see you next time.